Copyright law protects expressions fixed in material form. It allows authors to retain exclusive economic rights to do certain acts with an original work. Copyright is infringed where someone who is not the owner deals with one of these rights without authority or permission of the owner. There are exceptions to copyright law which include fair dealing, private copying, and statutory license. Today we're going to focus on the private copying exception and specifically time shifting. So what is time shifting? Time shifting is a type of private copying and is contained within Section 111 of the Copyright Act. It holds that, for example, if your mum makes a film or sound recording of a broadcast for you to watch or listen to at a more appropriate time, then the making of the film or recording does not infringe copyright, as long as she only uses it for private or domestic use. The exception covers things like TV programs and radio broadcasts. It doesn't cover such things as podcasts or webcasts, unless the program is streamed simultaneously with a broadcast by a traditional broadcaster. These are broadcasters such as the ABC, SBS, or one of the other commercial free-to-air broadcasters. What exactly is private or domestic use? Private or domestic use is defined in Section 10 to mean private or domestic use on or off premises. Therefore, your mum may lend the copy to members of her household or family for their own individual use. It wouldn't cover your mum if it was sold, hired out to someone other than members of the family or members of the household, or caused to be seen or heard in public, which would cover situations like lending it to your school to play on that rainy day. The exception will also not apply if the original work copied was already a pirated copy, or where the copying is carried out in a commercial relationship for the benefit of others. Back in the days of VCR tapes, this was a much simpler concept. But what happens when your mum records shows using her brand new fancy cloud digital video recorder? This situation is treated differently, as a cloud DVR is not something that the recorder can press start and then hold in their hands afterwards like a VCR tape. It is done through your service provider, who then stores the copy in your specific cloud, like for example the Optus TV Now system. In practice, the court generally focuses on who makes the copy. In the case of National Rugby League Investments and Singtel Optus, the time-shifting exception did not apply. This case involved Optus's TV Now system that allowed users to digitally record live or pre-recorded free-to-air AFL and NRL games and watch them at a later time. It was originally held that it was the users of the service making the recordings and that it therefore fell within the exception. However, on appeal to the full federal court, it was held that the recordings were made jointly by the user and Optus. Consequently, Optus was operating a commercial service where it made copies for the benefit of its subscribers, thereby excluding it from the time-shifting exception. Since this judgment, Optus has had to suspend its TV Now service until further notice. The federal court noted that this decision is specific to the situation between Optus and its subscribers. However, it is obvious that a clear ruling or amended legislation is needed in regards to emerging technology. But to sum up the exception as it now stands in the simplest of terms. Ordinarily, that time your mum recorded the late showing of Jurassic Park for you to watch later on would be an infringement of the copyright owner's rights. However, through the time-shifting exception, this is perfectly legal, as long as she made the copy herself and only lends it to family for private or domestic use.